Welcome to Off the Record, a legal podcast.
Hey everyone, welcome into an all-new episode of Off the Record with attorney Rhett Burney. I am your host, Mike Leon. Rhett here has spent more than 30 years helping families across the upstate of South Carolina navigate divorce, custody, safety concerns, and the court system overall. Today's episode, we're going to be talking about restraining orders specifically. What do they actually do? What don't they do? And how they shape everything from parenting time to communication during a case. Rhett, it's good to see you as always. Let me ask you a question here to start off. What exactly is a restraining order in South Carolina? How does it differ from, let's say, other types of protective orders that people hear about?
Sure, Mike, and thanks for having me. Yeah, we have various types of restraining orders, but if we're looking at it just in the family court realm, we may have restraining orders that prevent parties from being around each other, prevent them from calling each other, prevent them from dissipating assets or accumulating debt in the other person's name. So it's a very broad definition of what a restraining order means in the family court world. Lots of times people just think it's just limited to someone being around someone. We hear those urban legends of a restraining order means you can't come within 100 feet of someone or 10 feet. It doesn't mean that at all. It typically really just deals with you can't be around them, can't harass them, can't call them, can't email them, or also can't get rid of any of those assets we may be fighting about in a divorce.
Ray, let me ask you, if somebody comes to the office, they say they feel safe, they feel threatened. What are some factors that kind of help you guys determine whether a restraining order is appropriate under the law?
Yeah. Um, Obviously, we look at it on a case by case basis, and we want to find out exactly why that person may be afraid. Sometimes they say, well, my husband just says things that scare me. And then we'll follow it up. Have they taken any physical action towards you? Are they throwing things? Are they violent? Are they on drugs? As you can imagine, emotions run high in divorce cases and custody cases. So we want to make sure that we get down to really what's going on, because the last thing you want to do is to go into court and lose credibility with the judge and ask for a restraining order to prevent someone from being around another person if there are really no facts to support it. So we'll kind of dive into that just to make sure that they have kind of reached the mental bar that a judge would look at. Because as you can imagine, judges see all types of cases, and they see the very bad along with the not so bad. So we want to make sure that we're asking for a restraining order preventing someone from being in contact with another person, that the facts support it.
Yeah. So, Red, you said family court just a second ago. So let's say the restraining order is granted now. How does that usually affect the ongoing family court matters that could be happening? Let's say custody, visitation rights, communication between the parents. How does it affect all of that?
Yeah. So if it's a restraining order just saying that one person can't be around another, then what we'll do in a custody case or visitation case is arrange either a third party to pick up the child, deliver the child between the two parties, or the judge may simply say, there's a restraining order in place. However, we will allow the two of you to meet at a public place, police station, gas station, somewhere where there's surveillance, in order to exchange the children or child. And again, it really depends upon what facts led up to a restraining order be issued. Um, in South Carolina, we also have what we call a NACO order, NACO, no adverse contact order, which will still allow parties to be around each other, will still allow them to talk to each other, communicate with each other. But what it prevents is when people take it to the next level and they start the harassment, start the physical interactions. That would be a violation of the NACO. And as lawyers, we really like those types of restraining orders because it allows parties who have children involved or maybe having a common asset involved to communicate with each other. Because, Mike, as you can imagine, if you have a child or children with someone and there is a restraining order saying you can't contact the other parent, well, it becomes quite difficult when you're trying to arrange visitation exchanges or phone calls and those types of things. So we don't want to set people up for failure. So if it's just a really general run-of-the-mill type of case where emotions may be high, but there's not any type of physical violence or anything like that, we may just do a NACO, no adverse contact order, so the parties can still communicate with each other as long as it's done, in a professional manner, and doesn't rise to something that may be a little bit more onerous.
Yeah, no, and I'm glad you explained that process, especially when children are involved. So let me ask you, can you kind of walk the listeners out there through what actually happens at these restraining order hearings? Like, what's the judge looking for? What evidence is introduced, and what matters? And what should people actually expect out of these hearings?
Yeah. So, and let's differentiate. Let's go another example of what we may also have in place. Sometimes we have orders of protection. And in those types of hearings, the judge will sometimes hear testimony, sometimes will only look at affidavits. And an order of protection hearing is a hearing that's held usually when there has been some type of physical violence. And as a result of that hearing, the court will issue an order of protection, very much a restraining order. But if someone violates the order of protection, which usually prevents someone from even talking to the other side or being around the other side, communicating with the other side in any form or fashion, if someone violates that, they can be arrested and put in jail immediately. The other types of restraining orders we have are just simply the restraining orders, where the court kind of issues that relief as a collateral relief that it issues in any type of regular run-of-the-mill case where there's not a lot of violence or any violence whatsoever. And so that would just simply be where the court hears or reads affidavits from both sides. At a temporary hearing and a final hearing, it would be testimony. And as a result, the court will issue a restraining order saying the parties can't do X, Y, and Z.
I'm sure you've seen in your lifetime here doing this type of work cases where someone's either falsely accused or they believe the order is being used against them strategically during a divorce, right? How does the court kind of handle situations where the facts are disputed or a little unclear in those situations?
Yeah, and as you can imagine, in family court, the truth is not always told, or it's bent in a certain manner, or there's a lot of drama added to the facts, or people will just simply lie about the timing. They may say, "Oh yes, she hit me and it hurt, and she left a bruise," and forget to tell the court that it happened 5 years ago, right? Or something like that. So when a judge starts looking at issuing a restraining order, because it does, have an infringement upon your rights of sorts, because it limits what you can and can't do, the court will get into the facts very specifically, because the judge, they take it very, very seriously, thank goodness, when they start issuing restraining orders that say you can't be around someone or you can't do something, sell something. If it's in, you may have a business and the court issues a restraining order saying you can't sell assets in your business. Well, your business may not last very long if you can't sell what you're in the marketplace for. So the judges, they get in, they want to hear the facts. They want to know the specifics. They just don't want the 20,000-foot overview of the case and the fact that you just merely want a restraining order. They want to know why you want it and what facts you have to support it in order for them to make a decision as to whether or not they will grant a restraining order or not.
Right. Rick, can you share any stories that you've accumulated or any examples, client examples, without going too specific, obviously, where maybe the restraining order significantly changed the direction of the case, either by protecting somebody or by at least clarifying what the court needed to see?
Yeah, and pretty generalities. This is what we see lots of times. That these restraining orders are issued, and the court doesn't take into account the long-term effects. For instance, if the court simply issues a restraining order saying that parents can't be around each other and doesn't think about the fact that they're going to need to be around each other because they have children, well, that just causes more problems because now we have to find third parties to get involved. And Mike, I don't know about you, but the last thing I want to do is to have to be involved in someone else's mess, right? I don't want to be the third party that may be chosen to transport children. So the court also has to look at that as well, because it's not unusual for us to go into court and the judge asks us for a name of a third party that can be used as an intermediary between two parties. Well, of course, that third party's not there. Someone throws out a name, and then all of a sudden there's an order naming Rhett Burney as the intermediary between two parties. And guess what? Rhett has a life as well. So those are some of the types of things that I think people need to be aware of. Because if you're going into court and you're asking the court to issue a restraining order, think about what that really means in practicality. Because if you're saying that I don't want this person to be around me, Well, if you have children involved, how are you going to make the exchange between you and the other parent?
Right. Well, let's expand on that with some other examples. Like, what are some common mistakes that people have, or you've seen them make unintentionally, that have violated the restraining order?
Yeah. So if there's a restraining order about communication, sending a text, hey, how is our child? That is a violation of the restraining order. Even though you may not have talked to that person or called that person or even come to that person's home or place of business, a simple text could be in certain circumstances a violation. Or I've had judges, look at when one party has a third party contact the other party for some reason other than dealing with the children, the court will look at that and say that is a violation. I've also had people hide cameras, hide GPS trackers on their vehicles, and the court has looked at that as a violation of the restraining order as well. So if you are going to court and you're asking for a restraining order, be very specific in what you want the court to do, because if it is too broad, then it may prevent a lot of things that you haven't thought about. So, don't take asking for a restraining order very lightly, because it's not unusual for a judge to make that restraining order mutual, so that it applies to everyone, the person who asked for it and the other side who may not have asked for it.
Yeah. Red, as we land the plane on this episode, someone's listening to this right now. Let's say they just learned that the restraining order was filed, whether they requested it or they got served with it. What would you want them to understand about the impact that this could have on their case?
Yeah, first of all, don't call the other party and say, hey, what's this all about? Because that may be an automatic violation of the restraining order. Since the restraining order can, in certain circumstances, lead to you being put in jail, go to a lawyer, sit down with that lawyer, have the lawyer explain the ramifications of the restraining order, how it applies, what can and can't be done in order to make sure that you don't lose your freedom. So I would say go talk to a lawyer, if nothing else. Don't take it upon yourself to try to interpret the words, because you may not understand what those words mean and how a court may interpret those words if you're ever brought in front of the judge for violation of a restraining order.
That's right. I know one attorney that can help you with that. Rhett, thank you for the time and insights. I truly appreciate it, my friend.
All right, Mike. Have a good day.
Thanks to everybody out there for listening to this installment of Off the Record with attorney Rhett Burney. If you want to learn more, you want to connect with Rhett, maybe you've got a restraining order just filed against you, do me a favor, visit rhettburney.com today. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.